The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
Good morning. The first case on our docket is 20-10157. Ms. Penrose?
Good morning. May it please the court, my name is Margaret Penrose and I represent the petitioner, Mr. Garcia Ciriaco. The parties agree plain error occurred at sentencing and in the trial court's judgment. The government has conceded plain error in this case. Unless this court has any questions about the plain error committed, Mr. Garcia Ciriaco would prefer to move directly to remedy. Garcia Ciriaco bears the burden of proving that Judge Boyle's mistake affected the outcome in this case. Garcia Ciriaco will demonstrate that the judge's improper reliance on a 20-year maximum sentence influenced her decision to impose a sentence at the highest end of the applicable guidelines. This court should grant Mr. Garcia Ciriaco's request to remand for sentencing. There is plain error, the error impacted the sentence, and the fairness and integrity of judicial proceedings are called into question. There is a reasonable probability that had Judge Boyle conducted the sentencing proceedings using the proper statutory lens, Mr. Garcia Ciriaco's sentence would have been lower. Mr. Garcia Ciriaco was sentenced at the highest point of the applicable guideline range. This sentence would likely have been lower had Judge Boyle's primary and mistaken focus not been on the aggravated felony. During sentencing, the judge viewed Mr. Garcia Ciriaco in a light that unfairly elevates the seriousness of his past crimes. Mr. Garcia Ciriaco has not committed an aggravated felony. In fact, his crimes can be separated into three distinct categories. When these crimes and categories are placed in context, the sentencing proceedings look far different than those where Judge Boyle began by framing Garcia Ciriaco's sentencing under 1326 B2 for aggravated felons. The first category of prior crimes are the 4 voluntary removals. The government emphasized these at sentencing and before this court, but the true context is critical. Mr. Garcia Ciriaco first entered the United States on his 17th birthday, March 27, 2000. He was immediately removed. Over the next 8 days, he would again, at age 17, attempt 3 more illegal entries on March 31st, April 2nd, and April 4th. Judge Boyle specifically asked about these entries at sentencing on page 94 in the record. She asked how old Garcia Ciriaco was during these 4 voluntary removals. That question was never answered, but the information was in the PSR on page 106 in the record. These 4 voluntary removals all occurred within a 9-day span when Mr. Garcia was 17 years old. He was a minor. This context changes the sentencing assessment. This was not a years-long entry spree. This was a 9-day.
How old was he at the time of the conviction in this case?
He was in his mid-30s, Your Honor.
Okay, thank you.
The 4 voluntary removals all occurred within a 9-day period when he was 17 years old. So that's the first category of offenses that the judge was evaluating during sentencing. The second category of offenses is when Mr. Garcia's involved Mr. Garcia's state crimes. At age 20, Mr. Garcia Ciriaco was convicted for DWI. Then at age 21, he was twice convicted for drug offenses. These are the only non-immigration offenses Mr. Garcia has on his record. These state crimes occurred during a 2-year period when Mr. Garcia was 21 and 20 years old. The issue with this category is critical. Judge Boyle mistakenly overrepresented the seriousness of these offenses when she indicated her belief that Garcia Ciriaco had committed an aggravated felony. So her mistaken reliance on the gravity of these offenses negatively impacted her sentencing decision. She emphasized the prior offenses on pages 96 and 97 of the record. The final grouping or category of offenses are the adult illegal entries. Each of these offenses was a non-violent crime and were motivated by Mr. Garcia's desire to receive life-saving medical treatment here in the United States. The first conviction Garcia Ciriaco has for illegal reentry occurs at age 24 in 2007. Garcia Ciriaco, having been involuntarily removed in 2005, was convicted of illegal reentry before the Southern District of Texas. He received a 10-month sentence. The next illegal reentry conviction occurred 10 years later in the Northern District of Texas in 2017. Judge Boyle, the same judge that sentenced Garcia Ciriaco for this conviction, sentenced Garcia Ciriaco to 21 months imprisonment. Critical to this appeal, Judge Boyle specifically found no evidence that Garcia Ciriaco had previously committed an aggravated penalty during those proceedings. Thus, while the government sought in 2017 the heightened penalty provision under B2, Judge Boyle explicitly held that B2 did not apply because B2 could not apply. Judge Boyle in the judgment at that time changed the applicable penalty provision from B2 down to B1 because the government could not prove that Garcia Ciriaco had committed an aggravated felony. Garcia Ciriaco committed no crimes between the 2017 offense and the instant offense. Nothing changed factually. This leads us to the current 2019 conviction. Appearing again before Judge Boyle, the government sought to penalize Garcia Ciriaco under the proper penalty provision, B1, which carries a 10-year maximum sentence. The record demonstrates that the indictment was limited to B1. The guilty plea proceedings before the magistrate judge were limited to B1. And the U.S. attorney advised Mr. Garcia Ciriaco in open court that his penalty was limited to B1. Then came sentencing. Judge Boyle, without notice or legal support, sua sponte, began the sentencing proceedings by advising Garcia Ciriaco that his sentence would be determined under the enhanced penalty provision of B2. This mistaken understanding was literally the starting point for sentencing. Judge Boyle believed and conveyed that belief to Garcia Ciriaco that she was evaluating him under the B2 provision as someone that had committed an aggravated felony. This mistaken belief permeates the entire proceedings. This mistaken belief was at the forefront of Judge Boyle's mind when she imposed a sentence at the highest end of the applicable guidelines. Had Judge Boyle sought to impose a within guidelines sentence that was graduated, a step up from Garcia's past sentences, which appeared to double from 10 months to 21 months, she would have opted for a sentence in the middle of the guidelines, but she didn't. Her mistaken reliance on B2 resulted in a more serious sentence. Following sentencing, Judge Boyle again demonstrated that the aggravated felon provision was integral to her decision. The judge, in the judgment, changed the conviction from one under B1 with a 10-year maximum sentence to a B2 conviction. This unilateral, unprompted change reflects the importance that Judge Boyle placed on sentencing Garcia Ciriaco under B2. The court can see her thinking in the judgment. If the focus was simply on the applicable guidelines, there was no need to change the underlying conviction. If the motivation for selecting a 46-month sentence was solely the PSR, there was no need to change the judgment. But the judgment was changed, and it reflects the judge's lens for sentencing. Everything that occurred at sentencing was evaluated.
You say that the judgment was changed. I mean, there's no question, is there? But that he was convicted under B1, and that's the way his conviction reads, is it not?
That is incorrect, Your Honor. When you look at the record on, I believe it's page 53, Judge Boyle actually footnoted and changed in the judgment. She changed it from 1326 B1 to B2. And she footnoted the provision there and said the reason she changed that was that Mr. Garcia admitted at sentencing that he qualified for sentencing under B2. And that is actually factually incorrect. As the government notes in its brief, Judge Boyle's opening statement about the applicability of the heightened provision was unclear at best. So that's likely one of the...
Upon what did she base this incorrect statement?
Are you asking it how she arrived at that, Your Honor?
I'm asking you, yes, I'm asking you, upon what basis did she arrive at this incorrect statement when it was plain he had been convicted under B1? Is that not correct?
That is correct, Your Honor, and that is why we are asking for an entire resentencing. She made a mistake. Plain and simple, the judge made a mistake. She varied from what was stated in the indictment. She varied from what was presented during the Rule 11 proceedings, and she varied from what was presented in open court by the government, even in the PSR. I don't know what prompted or motivated that, but it is literally the first statement the judge makes after she swears in Mr. Garcia Ciriaco. She informs him and his attorney that she's going to be using an elevated heightened provision. And it's somewhat exacerbated actually as a mistake, Your Honor, because Judge Boyle made sure in the prior case that the facts demonstrated B2 didn't apply. She was very clear. And in that judgment, if the court looks at the judgment from 2017 and this judgment, the one consistency is a footnote placed by Judge Boyle, unprompted, unprovoked, and the motivation seems unclear. In the 2017 sentencing, she lowers from a B2 to B1. She realizes that there isn't an aggravated felony. But in this case, despite nothing changing, no evidence provided by the government, no argument made by the government, the judge evaluated the entire sentencing proceedings through a mistaken understanding of the governing sentence, the maximum statute. And when we look at everything that occurred at sentencing through this B2 sentencing prism, we realize that was the judge's sole focus. It was the focus at the beginning of sentence. It was the unspoken focus during her selection of a high-end guideline sentence. And it was her focus when she changed the judgment to memorialize her decision. Everything in this case centered around the mistaken application of B2. Judge Boyle's actions significantly impacted Garcia Ciriaco's sentence. It doubled the possible maximum sentence through which Judge Boyle selected her sentence. It was her starting place. It was her frame of reference, and it was an error that permeated these entire proceedings. Unlike several of the cases relied upon by the government, Garcia Ciriaco has proven that Judge Boyle's selection of a 46-month sentence, although within the governing guidelines range, was influenced by her incorrect understanding of the statutory maximum sentence. This fact distinguishes Mr. Garcia Ciriaco's case from the 2018 case U.S. versus Rodriguez Garcia, the 2017 case U.S. versus Ayala Nunez, and the 2009 case Mondragon Santiago. The Ayala Nunez case found no record evidence that the district court sentenced him based on a mistaken determination that his delivery offense was an aggravated felony. Here, that is the precise mistake that occurred. Another critical distinction between Garcia Ciriaco's case and the instant offenses where this court has declined to remand for resentencing is that the ultimate sentence in those cases was not at the highest end of the guidelines. Here it was. In U.S. versus Mondragon Santiago, the court sentenced Mondragon Santiago to a range at the lower middle end of the applicable guidelines, a 50-month sentence when the range was 46 months to 57 months. In Ayala Nunez, the court sentenced him to a range at the upper end, 60 months, but that was between 51 months and 63. Mr. Garcia Ciriaco believes he has proven plain error and that the integrity and fairness of these proceedings require resentencing. Thank you, Your Honors.
Thank you, Ms. Penrose. You saved time for rebuttal. Ms. Ricketts?
Good morning, Your Honor. May it please the court. Rebekah Ricketts for the United States. I'd like to start with a very important clarification. The government has conceded error below. The government has not conceded plain error. In fact, that is the very question before the court. The government's briefs made very clear that the proper remedy for the district court's error is to affirm the conviction and reform the judgment, not to remand for resentencing, because the defendant cannot carry his burden on plain error review. This court has said many times that all four prongs of plain error review must be satisfied for a full remand. And here the defendant fails both the third and the fourth prongs of the plain error standard. First, the defendant simply cannot show that the district court's error affected his substantial rights. The defendant must, under this court's precedents, show a reasonable probability that but for the error, the outcome of the proceedings would have been different. This court has repeatedly emphasized that that burden should not be too easy. That's the United States versus Mares case, 402 F 3rd at 521. The court has also said that if the effect of an error is uncertain, the defendant loses. In other words, a tie goes to the government. Here, as you've just heard, the defendant's primary argument is that his substantial rights were affected by the district court's remarks at the outset of the sentencing hearing about the, quote, higher penalty provision. The record refutes that argument for several reasons. First, contrary to the defendant's contention, the, quote, sole focus at sentencing was not on the statutory maximum penalty. The debate at sentencing and the judge's focus at sentencing was on the defendant's history of recidivism. 4 voluntary returns, 4 prior removals, 3 prior drug convictions, and 2 prior federal convictions for immigration offenses. The district court expressly considered the Section 3553A factors, including the need to protect the public and to provide just punishment, and ultimately decided that the, quote, fairest and most just punishment was a sentence of 46 months. A couple observations about that 46-month sentence that I think are critically important to this court's analysis. First, that sentence is at the high end of a correctly calculated guidelines range. There is no dispute about that. So there can be no question of a guidelines error somehow infecting the district court's analysis. That simply didn't happen. Second, also critically, the defendant's 46-month sentence is less than half of the correct 10-year statutory maximum. 46 months is actually 74 months less than the 10-year statutory maximum. Given the district court's analysis and given those facts, the defendant's prong 3 argument amounts to pure conjecture. The defendant simply cannot show that an ambiguous, off-the-cuff remark at the outset of the sentencing hearing negated the district court's analysis of the Section 3553A factors or created a reasonable probability that the result of the proceeding would have been different. Now, the defendant places great focus on the fact that the district court started the hearing with this comment about the higher penalty and claims that this was at the forefront of her mind. This was her sole focus at sentencing. But in context, Your Honor, I think the timing actually cuts the other way. As the court is well aware, it is customary at a sentencing proceeding for district courts to address all issues related to the PSR first, and then turn to the Section 3553A analysis that ultimately informs the sentence. In this case, there were no objections or other guidelines issues for the court to resolve related to the PSR. The only open issue from the PSR was the question of which statutory maximum applied. So the defendant's notion that this was a unilateral, unprompted change, that there was no notation in the PSR that could explain the district court's remark, is simply incorrect. The far more likely explanation for what happened here is that the court reviewed the PSR in preparation for sentencing. The PSR in the record at 103 asserts in passing that the higher penalty range applies, and the district court simply noted that issue and wanted to resolve that loose end on the front end of the sentencing hearing. But nothing in the court's explanation of its sentence, nothing in the parties' arguments indicates that the statutory maximum was remotely connected to the sentence that the court ultimately imposed. Now, defense counsel today wants to relitigate effectively the Section 3553A factors and claim that in an unspoken way, the statutory maximum infected the district court's analysis, and that's the only explanation for why the court would have selected a sentence at the high end of the guidelines. Your Honor, first of all, I think that's not the question for this court. This court is not to conduct its own 3553A analysis in the first instance. But even if this court were to look at the merits of 3553A, it makes perfect sense that this district judge would have selected a high-end guideline sentence, particularly in light of the fact that this was her second go-round with this defendant. And if you think about that, that's a pretty remarkable fact. How many district judges have the opportunity to sentence the same defendant twice?
Some courts, they have many, many, many opportunities. That's not uncommon at all in certain districts in Texas.
I understand the court's point, Your Honor. My only point here is that there is a history with this particular defendant. The court has seen him before, and this defendant has continued to reoffend.
But you do see that she was mistaken about what the statutory maximum was. What's your response to that she changed the judgment?
Your Honor, the district court did note the statutory penalty in the judgment, but the court did not change the judgment. I think I disagree with counsel's characterization of the record on that point. In this case, as in every case, the district court entered a judgment that reflects both 1326A and the relevant statutory penalty. But the court did not issue one judgment and then amend it to reflect a second statutory penalty. The court noted in its footnote the reason that it adopted the B2 penalty in light of the colloquy with defense counsel at sentencing, and the government agrees that was error, but the judgment was not changed from a B1 to a B2. So, Your Honor, given all of those facts taken together, we think at the very most, the effect of the district court's error is uncertain. We do not think that the defendant has carried his burden to show a reasonable probability that is sufficient to undermine confidence in the outcome at sentencing, which is his burden on prong 3. However,
recent Supreme Court cases give me pause, I must tell you. Did any of those tell you that maybe the Supreme Court looks at factors 3 and 4 of the plain error standard differently than this court formally did?
It's a great question, Your Honor. The short answer is not in the context of the question of a statutory maximum error as opposed to a guidelines error. I think the critical distinction between an error with respect to the guidelines range and an error with respect to the statutory range is that district courts are required to use guidelines as the starting point for sentencing and remain cognizant of those guidelines throughout the sentencing process. That's Molina-Martinez. Statutory ranges, by contrast, simply set the floor and the ceiling. They do not anchor the district court's discretion. They simply set the outer bounds. I would refer the court to a Third Circuit decision, United States versus Payano, Payano, 930 F 3rd at 193, which is a Third Circuit decision from 2019 that I think has a helpful discussion of this distinction. The Third Circuit's conclusion on this point is that it makes perfect sense that courts of appeals, both before and after Molina-Martinez, have rejected arguments that a statutory range error should be treated in the same way as a guidelines error. Because unlike a guidelines error, the erroneous statutory range is not itself sufficient to show a reasonable probability of a different outcome, which is why that third prong inquiry is so important. Unless the court has further questions about the third prong, I would turn briefly to the fourth prong inquiry. Separate and apart from the flaws in the defendant's prong 3 showing, we think there's a separate reason why this court should decline to exercise its discretion for full remand. And that's because the defendant also fails to show that the error seriously affected the fairness, integrity, or public reputation of judicial proceedings. This court has said that prong 4 remains a stringent requirement and that it is not automatic if the other 3 prongs are met.
You said that even 3 months meets prong 4, I thought.
Your Honor, that may be true with respect to a guidelines error. I do not think that it is true with respect to a statutory range error, which is what's at issue here. We think there are at least 2 reasons why the defendant's attempt to make a prong 4 showing fails here. The first, again, is that the defendant's sentence is within a properly calculated guidelines range and is 76 months below the correct statutory maximum. The defendant has identified no case where this court has exercised its discretion to correct an error in remotely comparable circumstances. And the absence of that authority makes perfect sense. It's difficult even to imagine how a hypothetical higher statutory maximum could offend the fairness, integrity, or public reputation of judicial proceedings where the defendant received a guideline sentence that is less than half of the correct statutory maximum. But the second reason, Your Honor, that I think the defendant's prong 4 argument fails is that this defendant has a 20-year history of immigration violations. Again, multiple voluntary returns, prior removals, and prior federal immigration convictions. This court has repeatedly declined to exercise its discretion on prong 4, where the defendant shows a propensity to repeatedly commit the same crime. And those are exactly the facts of this case. Unless the court has further questions, the government would rest on its briefs.
Thank you. Ms. Penrose?
I'd like to clear one thing up to be absolutely certain. I'm not suggesting the petitioner is not suggesting the government that the judge changed the judgment after entering a judgment. The allegation, the assertion is that Judge Boyle entered a judgment that is in contravention of the indictment. It's in contravention of the Rule 11 proceedings. And a B2 finding is not irrelevant. In fact, in some ways, this is a more serious violation than a guideline range violation. Under U.S. versus Perez Jimenez, A B2 finding renders an individual permanently inadmissible. So that has a gravity of consequence that has not yet been addressed. If that remains erroneously on his record or any individual's record, then that becomes a serious question of the fairness and integrity of the judicial proceedings. There is no uncertainty here. Judge Boyle's starting place and ending place was on the wrong statutory maximum guideline. When she said it in sentencing in these other offenses, I think the fairest thing, the most just punishment, considering the safety of the community and providing just punishment, is 46 months. That safety of the community comment reflects the judge's misunderstanding of Garcia-Ciriaco as falling within B2's aggravated felon provisions. Relying on an improper sentencing statute when sentencing an individual to the highest guideline range offends basic notions of fairness and integrity. If your selection is made based on wrong information, then your selection is flawed. If you show your selection was influenced by that wrong information, by unilaterally changing the judgment or the statute under which the person had been indicted, you're demonstrating your reliance on the flawed information. The property remedy here is resentencing.
You keep saying she changed the judgment, and I don't mean after it was entered. Did it say B1 and she changed that to B2?
Your Honor, no, the indictment was B1. And during—
You keep saying she changed the judgment. You keep using that terminology.
And that's why I said I wanted to make sure I cure that. It's not that she changed the judgment. She entered a judgment that is different from the crime for which
That's different than changing the judgment.
You are correct, Your Honor, and I want to make sure I'm clear then that the statement is truly not that she changed it either after the fact, but she issued a judgment that is different for the crime for which Mr. Garcia-Ciriaco was indicted. The government puts some emphasis here on the fact that the within guidelines range was only 40% of the sentence. But if Judge Boyle was trying to show leniency, 46 months compared to 20 years is very different from 46 months to 10 years. Here, if the proper lens had been used, one where 10 years served as a maximum, then a 46-month sentence is nearly 40% of the maximum applicable sentence. This would be nearly twice the penalty intended. If the goal was to sentence Mr. Garcia-Ciriaco at a quarter of the maximum, like the 46-month high-end guideline sentence under the mistaken belief of a 20-year applicable sentence, then using a 10-year sentence, the governing statute or the penalty should have been around 30 months or at the very low end of the sentencing guidelines. You know, it's nearly possible to unscramble the sentencing egg in this case, but I'd like to try by way of analogy. Imagine you have a family recipe for an omelet. That recipe calls for 1 cup of ham, but your copy mistakenly indicates that the recipe calls for 2 cups of ham. You make the omelet, you realize the mistake. What's the best way to fix it? Do you serve that omelet and just change the recipe so that the mistake doesn't happen again and it doesn't affect other individuals? Or do you realize that you should probably make a new omelet? Mr. Garcia seeks a new omelet. Changing the recipe may help the next person, but he's the one that received the 2 cups of ham when only 1 cup was called for. Thank you, Your Honors.
What happened to the first omelet? Somebody eat it?
That's the question, Your Honor. Is that an omelet that should be forced on the person at the table, or do you realize your mistake and realize that the recipe was wrong? And the better solution is not waiting to correct it for the next person, but to correct it for this individual and give him his 1 cup of ham omelet.
Okay.
Penrose, you're court appointed, and we very much appreciate your willingness to represent the defendant in this case. You've done an excellent job. Thank you.
Thank you, Your Honor.
Case is under submission. Thank you.